Good evening from Washington. I'm Larry O'Connor. Earlier today, the Supreme Court released one significant decision amongst a handful of lesser importance, and it had to do with election law, and most specifically, the role of state legislatures in determining election laws and protocols for federal elections. This might get us closer to resolving something that's been up in the air and frankly, the subject of hotly contested debates over the last several years. Joining us right now to dissect the decision is J. Christian Adams, president of the Public Interest Legal Foundation and the founder of the Election Law Center. Mr. Adams, thanks for joining us tonight, as always.
Thanks so much, Larry.
So this has to do with whether the courts have a role in overseeing what the legislatures do. In fact, there's some school of thought that said that the legislatures have supreme power over these, even over the governor. Is that right?
Well, right, and Public Interest Legal Foundation actually filed a brief in the case arguing that the Constitution says what it says, but the Supreme Court disagreed today and said that state judicial review plays a role also, and they cited Marbury versus Madison, which is this ancient cases.
Isn't that like the first Supreme Court decision? I remember that from my U.S. history class in high school.
Right, and so when you read Marbury showing up in an opinion, you know things are going to get serious. But look, this was not a big surprise. I mean, the North Carolina legislature lost. Our brief obviously didn't persuade the court, but it's not a huge surprise. I mean, the court had said in an opinion 100 years ago that the governor can veto a state legislative enactment on elections, and that's okay under the Constitution. It ruled that the state of Arizona can give away its power to a referendum, and that's okay with the Constitution. So today the court just said, the state Supreme Court can review it too. So it's not the biggest surprise. I wish it had gone the other way, but it's not the end of the republic.
But you and others who also wrote briefs in support of the losing side today, if I may use those terms, you were, as you said, saying that the Constitution says what the Constitution says, and the last time I read the Constitution, it said that each state legislature shall determine this. If they had meant through their legislative process with the governor and the Senate, they would have said that, but they didn't.
Well, look, that was the argument we made, and the court rejected. And it said that, you know, when the Constitution was enacted in 1787, that there was state legislative review by courts, and that the governor in some states way, way, way back in 1787 could veto election laws. And so what the court said was, look, this was part of the bundle of state activity. When the founders wrote state legislature, it included vetoes, it included judicial review. That's sort of what the court did today. It's not a completely unreasonable argument. Okay. It was just a very close call that went the other way.
And this, by the way, is called the independent state legislative theory, right? That's the legal theory that this was built on, that your argument was. But there is another decision that we're still waiting on that is still in play with regard to who gets to have the final say here, isn't there?
Well, you know, this is a very complicated procedural history with the state of North Carolina. The best part is the state Supreme Court reversed itself. It said that you can't have partisan gerrymandering, and then a whole brand new court after an election said, oh, yes, you can. So it's all kinds of crazy.
Okay. Now, this also has certain ramifications with regard to looking backwards to the 2020 election and also looking forward to the next presidential election. Because Lord knows, J. Christian Adams, they're going to try to do the same thing that they did last time, which is if a state legislature, even if it's signed by a governor, comes up with the protocols and laws that govern the federal election procedures in any given state, Secretary of States are going to try to step in and make some last-minute changes, or they'll find a friendly judge to say, oh, no, we're not going to count the ballots that way, or we're going to allow mail-in ballots this way. So does this open the door for more shenanigans?
No more than it was already open, Larry. What was happening in this case was the North Carolina legislature was trying to throw a Hail Mary pass on the Constitution. They were trying to lock down a wall, to put a wall around state judicial review. It was a big ask, okay? And we supported that ask, but it's not going to change anything. And yes, indeed, it's still going to allow the same mischief that occurred in 2020 because state Supreme Courts will be able to review laws. Look, that's how we've lived in this country for 200 years. This is not a radical change. is we were trying to get limits on the power of courts to review this, and we failed.
Setting aside the question of whether courts should have this oversight or not, I'm seeing some commentators from the conservative spectrum seeing this decision, and their reaction is, well, we need federal laws. We need Congress to step up, and there should be more federal laws so that it's consistent from state to state. How do you argue that?
Terrible idea, because the founders wanted to delegate power to the states because it was a check on tyranny. What the founders feared correctly was federal tyranny. So the last thing you want to do is give people like the Marxist from Vermont, Bernie Sanders, and all of the disastrous figures in Congress any more power over this. Congress can go the other way. Do not view Washington, D.C. as the solution. That's what Ronald Reagan told us, and it applies here.
But doesn't that mean then that the good people of Oklahoma, no matter how politically active they are and how conscientious they are in making sure that their voting system is protected and solid, we're still beholden to the whims of the legislatures of California and New York?
Yeah, and that issue was decided in 1865. And right now we're bound up together with all the mystic chords of memory. And we just have to learn to find a way to respect the federal design of giving states power. And when we can tinker with it to make it better federally, okay, let's consider it. But that is a dangerous Pandora's box that some people want to open to get Congress involved.
All right, so leave Congress out of it. That's a good rule of thumb. I'm down with that. How goes the efforts? I know that through your organizations, you've been working on a state-by-state basis to try to move things along so that we do have a fairer and more sensible and legal sound election system. How are things looking right now in your estimation?
Yeah, really good in a lot of places. I mean, there's been a lot of energy by a lot of different groups and people the last 2 years to improve the system. There's still some problems out there. As you know, we had a deposition today in our Michigan lawsuit for 25,000 dead voters. And so some states are still dug in ideologically with their head in the sand about the problems. Michigan tops the list. Pennsylvania's right there. Wisconsin, I wish those 3 places were better. But there are places where things have gotten better that were a problem in 2020. Arizona, Georgia, and other places like that have gotten markedly better.
When you say 25,000 dead voters, you mean 25,000 dead potential voters on the voter rolls, or do you mean 25,000 votes that were actually cast by dead people?
Well, it's a mix. Yeah, it's 25,000 registers. There's way more than that. These are only the really old people that we found. We didn't even spend the money to look at how many dead 25-year-olds there were. But yeah, it's a mix, and some of them do vote. Judith Presto voted in Pennsylvania, for example. She registered after she was dead. That's a real winner. That's a phenomenon I don't think people quite understand yet. It is happening. People are getting registered to vote after they died, usually by family members.
Wow, I'd be careful if I were you. If you go to Michigan, there could be ghosts right around the corner there, or there's some sort of resurrection effect happening. But I'm glad that you're on top of it. I thought that only happened in Chicago. I guess it's blood across Lake Michigan. Thank you, J. Christian Adams. Great stuff as always. I appreciate it.
Thanks, Larry.
So there you go. He actually wrote one of the briefs with today's Supreme Court decision, and he doesn't seem too upset about it. But, you know, you live on to fight another day. That's what we do. There's more to come on O'Connor tonight. Keep it here. We appreciate you watching the Salem News Channel.